Namaskar and welcome to the Citizen Justice Forum Legal Awareness video series. Citizen Justice Forum is a public awareness initiative dedicated to educating the citizens of India about their fundamental rights and legal rights, constitutional protections and remedies available under various laws of the country. Many citizens lose their hard-earned home, businesses, properties, not because they have no legal rights, but because they are unaware of the remedies available to them at the right time. Through this series, we invite distinguished legal experts from across India to simplify complex laws and empower citizens with practical legal knowledge. Today, we are discussing one of the most important subjects affecting the borrowers, home buyers, businessmen, guarantors, senior citizens, and families across India. SARFAESI Debt Recovery Appellate Tribunal and the legal remedies available when the bank initiated recovery proceedings. Now, the objective of this discussion is not to encourage loan defaults, rather it is to educate citizens about their rights and obligations so that they can make informed decisions and avoid losing their properties due to lack of awareness or lack of knowledge. To discuss this important topic, we are privileged to have with us Advocate Narendra Athavale, an experienced practitioner from Ratnagiri who has been handling SARFAESI matters for many years. He is a second generation lawyer. His father was also a very well established and very well recognized advocate in Ratnagiri, and he is also a commissioner appointed by the court to take the possession of the properties which the home buyer or the loan taker has defaulted. So we welcome to the Citizen Justice Forum podcast Advocate Narendra Athavale.
Thank you very much, sir. It is a very big opportunity for me to actually share my views regarding to this important topic regarding SARFAESI, and it's a very good forum to make awareness amongst the citizens regarding to their rights and all the proceedings so that they can actually understand it in a simple way. Whatever the experiences I have got as a court commissioner as well as by filing the matters before the CJM court Ratnagiri, I will try on my level best to actually elaborate and simplify the act to the citizens by way of this particular podcast.
So before we go any further, can you share one or two experiences where you had gone to attach the property, whether it was a house or whether it was a business house, right? So what were the experiences? Who were the borrowers? They were a willful defaulter or it was the circumstances which created them to be a defaulter?
Yes, there as a court commissioner, there have been a lot of experiences, and in last 3 or 4 years after actually executing a lot of orders, there have been a lot of experiences which the court commissioner, as a court commissioner, I have to. One or two instances I would like to share is that one instance there was a particular case where the default by the borrower was due to a genuine difficulty. And the fact that the default of loan, EMI, by that particular borrower was due to some emergency or any particular genuine reasons was not known to me as a court commissioner, because as a court commissioner we come into picture after the court has passed the order. So till that time we have not concerned with any particular background of both the parties, whatever are there. Most importantly, court commissioner comes in the shoes of the court. So he has to be obviously a neutral person, and he is the person who is actually acting in the shoes of the court, and so he has to deliver the possession of the property. In that case, sir, the borrower actually cooperated me very much in the all proceedings. Even when we went to the property, he actually opened the house and almost all the whatever his belongings were there, he actually had taken away. After the preparation of Panchanama and all the procedure which was actually expected by the as a court commissioner was completed, he just came and started crying. And I just asked him that why are you actually crying? Then he said there was some difficulty. He had lost his actually wife during the pandemic period, and due to that particular reason he could not actually go and repay the EMIs properly on the regular basis. And after that the default happened, and the entire proceeding which was there, all the process was completed by the bank. So he actually didn't go and actually intimate the bank that so and so difficulties actually arise, and that's why I'm not able to actually pay the EMI. Had it been a case that this difficulty was actually put up before that particular bank, there would have been, the bank would have considered that particular difficulty also. Because end of the day, most of the borrowers are actually thinking in a way that these court commissioners as well as the banks, they are persons who actually don't have any emotions, or they are not humans in that sense, because they are taking the possession of the property. It is not the case, sir, because every person is actually having that emotions and particular things. It's a part and parcel of the duty which the bank actually executes as well as the court commissioner executes. There have been another instances. This was example I said about the genuine, if there was difficulty was there. There have been lot of examples where there have been willful default by the borrowers, and there have been very violent possessions also, because they actually when we go to the place, we are unaware about the locality, because we are not coming to the contact of the particular borrowers any day. It's the first and only time when borrower is actually seen. And there have been experiences where there has been very violent the borrower has become violent. And in that cases, sir, when police protection is most important, because police machinery, when it comes to actually aid, or we can help the court commissioner of the bank, then it is their duty actually to prevent any particular violent act by any particular borrower. And importantly, sir, then in such cases, what happens is we become little bit sometimes it becomes that a court commissioner, being a court commissioner, it becomes a panicking situation also, because we are not actually used to that any particular threatening or all these things. But after, sir, 2 or 3 instances there have been there which I have actually experienced, I have seen that there has been threatening there. Even, sir, in one case I used to get, when I sent a court commission notice, I actually used to get a notice reply by the borrower almost every second day, which he used to send, and he used to address that particular reply to all the politicians and all those things and this, so that they actually think, sometimes the borrower thinks that if we give the reply, court commissioner will not come to the place. Even, sir, there have been 1 or 2 instances where the borrower actually has approached any particular interference of politicians also, or any particular big influencing people, so that they actually directly call the court commissioner and say that you just don't go and execute the order. We will try to actually make the settlement at the before we go to the particular court commission. These have been some very interesting court commission experiences. Even, sir, there have been experiences when at the time of court commission, the borrower has actually moved for stay application to the DRT, and wherein by the video conferencing or what hearing is there, the DRT has asked the banks to actually request the court commissioner to wait for some time till the further stay order hearing is actually completed. So lot of experiences are there. There have been very positive experiences also. There have been some cases also, sir, where there has been a compromise by the borrower even before the court commission work is completed. Because court commissioner work is not that if today the court has passed the order, tomorrow I am going to go and take the possession. It is not the case. It is mandatory for the court commissioner to send the 15 days notice to the borrower, so that he gets the intimation that yes, my particular property is going to be taken physically by the bank, by the court commissioner as per the order of the court. And therefore, sir, in that 15 days time also, there have been cases where the borrower has tried to pay some amount, even at the time of court commission also. There have been times where OTS proposals have been actually there, part payment has been made. And so, in short, if you ask, then all types of experiences actually have actually been taken for last 3 or 4 years as a court commissioner.
Now, can you, in a simple language, explain to our viewer what is SARFAESI and what is the process in simple language, so that every citizen can understand when to act and how to protect the rights?
Yes, sir. SARFAESI, now this act stands for Securitization and Reconstruction of Financial Assets and Enforcement of Security. Now this act came into force in the year 2002. It's a special statute. It comes under the criminal law. it's a miscellaneous application under the purview. It comes under the purview of miscellaneous application. Now, why this act came into force? Because before this act came into force, the only remedy which the bank or the institution, financial institutions, had to go to the civil court and file the suit for recovery of loan amount. And Civil Procedure Code 1908, as we know, it's a procedural part of the civil law, wherein all the procedure actually has to be followed. And in that case, sir, adjudication of rights is actually be taken place in civil matters, whereas in SARFAESI there is no adjudication of rights. So give some, what we can say, some expedient relief to the banks. This act came into existence in 2002.
To make you more simple, like if instead of SARFAESI, if the bank had to follow the city civil code, it will take decades and decades for the bank to get the order, right?
Yes, sir.
And the borrower, where our money is there in the bank, right, would enjoy the money without paying the interest, and the bank may collapse. Similarly, the enactment, the intention of enacting RERA Act was to give a quick and affordable justice to the home buyer. So this way, SARFAESI Act was enacted to give a justice to the bank who has been lended the money or given the loan to the home buyer or to the businessman. Now, we should know if we issue, if the notice is issued to us in SARFAESI Act, then how it is important and how we should, react to it, or how we should respond and don't get into the panic.
Yes.
So what is the rights available to the borrower if they issue such type of notice?
See, under this act, first of all, the most important thing is that when a particular loan becomes a non-performing asset, that is NPA, then only Section 13 notice and 13(4) notice comes into picture. Now, what is the meaning of NPA? NPA is the meaning of NPA is that when a defaulter, that is a borrower, has not actually paid the EMI for 3 consecutive months or 90 days, and after that 90 days, that is the completion of 3 months, the account becomes non-performing asset, and the bank declares that the particular loan account is an NPA account. So after that NPA account, when it is first declared, then sir, Section 13(2) notice under this act comes into picture. Now what this notice says, it's called as a demand notice. It's the very first beginning procedure as far as SARFAESI is concerned. Now this 13(2) section, what it speaks about, sending of demand notice to the borrower, that is after the account is declared as a NPA, and under this notice, a 60 days time period is given to the borrower. Now the bank doesn't say that under this section that we are going to attach your property. People think that they are going to attach the property. That is the only thing this notice mentioned. It is not the correct thing, sir. In this notice, the first foremost, the thing which the bank does is calls upon the borrower to make the regular payment of the loan. So whatever NPA is there, to come out of that NPA and to regularize the loan account, that is the first thing which the bank asks under this notice. Subsequently, if you are not in a position to make the NPA, or if you are not going to position to regularize the account, then this notice contains what are the remedies the bank is going to take after the completion of 60 days. In that particular period, sir, the Section 13(3)(a) of the SARFAESI, it speaks that the borrower actually can reply this demand notice. Now that demand notice can be replied on few grounds. The grounds may be that if the amount has been actually deposited but not reflected in the bank loan account,
In the ledger.
if there is no misrepresentation is there on the part of bank, or there is not a proper cooperation by the bank, these are the few grounds, or there is a, what we can say, if there is a wrongly mentioning of NPA, these are the grounds on which the borrower actually can reply this notice. Once this notice is replied under Section 13(3)(a), the bank has to actually inform within 15 days whether the objection has been considered or not. Now, one important point here I would like to actually share is that if the objections have been not considered by the particular bank after the 13(2) notice is there, it is not that the borrower can go directly to the DRT, that my objections have been not considered by the bank. It is not the case. That is only one of the opportunity. You can put up their particular whatever the things are there, whatever the reasons are there for default. What is your mentality as a borrower? Whether you have honest intentions to actually make the payment. All these things you can reply by 13-2 notice. So that is the first time when the borrower can reply 13-2 notice, which is oftenly actually neglected by the people. People don't actually consider. They consider as a general notice and they forget about it. After this 13-2 notice, under section 13-4, the bank sends another notice that is for taking the possession of the asset. Now that possession of the asset can be a symbolic possession as well as the physical possession. Now, the difference between the symbolic possession and the physical possession is that when symbolic possession notice is issued, there is no order of the court. There is no specific order by the court, nor there is any help of the police machinery. So bank officials goes to the property and actually prepares the panchanama in the presence of the two pancha, and in that presence they actually prepare the panchanama and take the possession on paper. So that is called a symbolic possession. And after that also, sir, the symbolic possession, once it is taken, most of the times banks actually issue that in a paper publication in the newspapers, English as well as Marathi, if for example, whatever the language there is there. So paper publication is also made. Actually 13-4 publication is not what we can say, it can be done as per the provisions of particular bank, whatever is there. So 13-4 notice is issued, 13-4 notice symbolic possession is taken. After that possession is taken, then it is actually reflected in the newspaper also. So and so possession was taken by the bank by the particular defaulter of the borrower. After that, sir, if 13-4 also notice can be replied, and then objections if there are, they can be actually given by the borrower. So there are certain times at the earlier stage before the Section 14 application is filed before the concerned court, borrower can actually go and put up his whatever his remedies, whatever he wants to actually convey to the bank, he can convey that.
Yeah, I have one question. Now, suppose Mr. A is paying an installment of 50,000 each. So he has not paid for the 3 months. So it becomes 1,50,000 rupees. So the bank makes that account NPA and they issue a notice. Now he is not able to arrange 1,50,000 at a go. He says, now I am paying 50,000 rupees. And give me some time, I will clear out this thing. So can bank consider that?
Yes, sir. That can be considered by the bank.
So,
because it is not possible every time that borrower is going to pay the NPA amount at one stroke. But that can be considered by the bank depending upon the type of loan and the circumstances, whatever are there.
So in that case, if some communication is made with the bank and some amount is being deposited, so the bank will know that intention of the borrower is not malified and he is ready to cooperate. There may be some difficulties because I have seen n number of cases where due to COVID, a good business house or a good family, they have faced many difficulties, not because their business was slow, because some of their relatives were hospitalized and they had to spend a lot of money. So that whole monetary aspect was gone for a toss and it was not a willful defaulter. In case of willful defaulter, I can understand if the SARFAESI notice is issued and the possession is taken and then it is auctioned because they have done a willful default. But in such a cases, bank, if you can approach them and they say, "Bhai, abhi 1.5 lakh की जगह पे मैं अभी 50,000 भरता हूँ, kindly consider and give the evidence that so and so thing has happened and I have spent so much amount in the hospital bills. So some time may be granted to me to regularize my account and bank may consider that." And if you go with that intention, and even that if the bank doesn't consider, then I think you can approach the DRT to show your intention that you have already deposited one of the installment and seeking some time. So the DRT may be also, grant you some relief.
Yes, sir. It can happen.
Now we heard, with the SARFAESI and all, we are hearing it ARC also. Can you put some light on what is this ARC?
Yes, ARC means Asset Reconstruction Company. Now, Asset Reconstruction Company is a company who actually takes the rights from a particular bank by way of procedure as far as the section 3 is concerned. Now those particular institutions, financial institutions, when they actually transfer their rights along with the loan and all the procedure, in that case that ARC will come under the same rights as far as the bank is concerned. For example, to elaborate, if a person has taken a bank from B bank, and if that during the tenure of the particular loan account or the loan is in existence, if that B bank has actually transferred his the rights to a company, that is a C company, for example, and as per the procedure of section 3 of the act, under the guidelines of Reserve Bank of India, sir, when it is actually taken into consideration and the ARC has been given approval, then that ARC will come under the same shoes of the bank, and it will actually continue with all the rights which the bank actually has got from the borrower A in this case.
And what happens if there is an outstanding amount is less than 20% of the principal amount and the interest thereon?
Yes, sir. According to sir, most important thing under SARFAESI is that it is not applicable in certain cases also. First case is that when the loan amount is not more than 1 lakh, that is, if the loan amount has been taken is not more than 1 lakh, in such cases also SARFAESI doesn't come into picture. Second thing is, if the mortgage property or the secured asset which we say under this act is an agricultural land, in that case also, sir, SARFAESI doesn't come into picture. And third thing, as we just now asked about, if the outstanding amount along with the interest, if total aggregate is less than 20%, then also, sir, SARFAESI proceedings cannot be initiated by the bank. So, which means that if the borrower is actually has repaid the amount, or if the outstanding amount is less than 20% of the loan sanction as well as the principal accrued, whatever as per the terms and conditions of loan agreement are there, then in such cases also the borrower actually can say that bank cannot actually initiate SARFAESI proceedings, and then that can be one of the good ground that the proceeding can be actually stopped under SARFAESI Act.
So, when you receive such type of notices, always, go to a legal advisor, your chartered accountant, your advocate, take a right advice and act accordingly.
Yes, sir.
Now, one of the biggest problems I have observed is that the borrowers often do not understand the timeline. Can you explain the complete journey from a simple EMI default to an eventual auction of the property?
Certainly, sir. It is not a case that the property is lost in one night. The first stage, as far as when the borrower starts to lose his property, is the first thing is when there is a EMI default, when the borrower does not pay the EMI regularly. If the second stage comes into picture is when the EMI, when default is there are cases where in few cases where that the account is mentioned as a SMA, that is a special mention account, whereby at the early stage after the loan actually has been sanctioned by the bank, where the bank feels that there is not going to be recovery of the amount, or there is not going to be a regular payment from the particular borrower. So there are also 2 or 3 types of actually special mentioning accounts. Duration is there, stage 1, stage 2, stage 3. Stage 1, it says about when default is of 30 days, stage 2 is 31 to 60 days, and third one is 61 to 90 days. That is special mentioning account. Third thing, as I just now mentioned, is about classification of the amount as a non-performing asset when the bank has actually declared the account as a NPA. And that NPA, it happens, as I said, when there is a non-payment of EMI for 3 consecutive months. Fourth one is that the notice which is sent under section 13(2) of the SARFAESI Act, which as I said, it is called as a demand notice. Then fifth stage is that replying the notice under section 13(2), under section 13(3)(a), where you can reply the demand notice. Next stage which comes into picture is the section 13(4) possession notice, that is a physical possession or the symbolic possession. Sometimes also, sir, the banks actually boost the possession and it actually keep any person to actually manage the property. There are some loans where the factories are actually mortgaged. In such cases, sir, so to enable that the workers are not actually affected by the default of his owner, at that time also sometimes the bank actually keeps management of the property under the 13.4 notice is there. Next is that after all this procedure is completed, the application filed by the bank to the concerned court, that is metropolitan magistrate or a judicial magistrate, chief judicial magistrate, or a particular district magistrate under section 14, where after that proceeding is completed, the court allows the application and appoints a court commissioner to take the physical possession of the secured asset. Next is that in between, as I said, after the section 14 application is allowed, and when the court commissioner issued a notice to the particular borrower, in that 15 days period also, sir, the borrower has the right to actually make payment. After the possession is taken, sir, the borrower actually loses his right. So there he cannot go and actually take the possession of the property by force or by making any particular action which is not actually considered by the law. That is house trespassing or breaking. That cannot be allowed. And last stage which I said in this I can say is that after the possession is taken, auction notice when it is issued by the bank, and after the auction process, it is actually sold in the auction. And in that case, if there is if the amount which is recovered is more than the outstanding, the surplus amount is given to the borrower. So these are the few stages in which the entire journey takes place under SARFAESI Act.
So what I understand is that every stage, different legal rights and remedies are available.
Yes, sir.
Right? Now, at which stage should a borrower stop ignoring the problem and immediately seek legal advice?
As I said, under section 13.2, when the demand notice is issued by the bank, at that time the borrower should actually make the honest intentions. And as you said just now, that the borrower should approach a particular, take the consultancy of any particular advocate or CA. And then at that time, sir, 13.2 notice when it is issued, the first opportunity the borrower gets. So it's the beginning of SARFAESI proceedings till actually execution is there. So if 13.2 notice is not required on time, then there's very, very less chances are there that even 13, because if 13.2 is there, then 13.4 will come into picture. If all these things are being sorted at that initial stage, then which are not unhappy circumstances can be avoided, which can happen in future.
Sir, you have repeatedly referred to section 13.2. Why is this notice so important?
Sir, this notice is the foundation of entire SARFAESI proceeding. Under this provision, when the bank issues the demand notice, requiring the payment of outstanding within 60 days, and in that notice, sir, the bank actually doesn't say that we are going to take your property. They actually, as I said, they actually ask that to make the repayment. And therefore, if you make the repayment, as I said in my previous question, that next proceeding can be actually avoided. So 13.2 demand notice, which contains about the loan agreement, the mortgage which was created, what was the EMI, how much default has been made, how much actually amount has been recovered, and what the consequences will be there if there is not going to be a repayment of the loan amount by the borrower. That is all things are mentioned under section 13.2, and as I said, it's a 60 days notice has been given. So it's a quite a lengthy time, long time. So before 13.4 actually proceeding is initiated, in simple terms, as I have elaborated, the borrower gets at least 5 to 6 months time to actually, since he has last made the payment of EMI.
So what I understand, that 13.2 notice is a notice that where you can approach the bank and you can regularize your account which has been turned into an NPA. If you are able to do it successfully, then the question of 13.4 and section 14 notice and the procedure can be avoided.
Yes, sir.
The bank, what they want is the borrower should pay their money. And now where does the bank get money from? It is our deposit, our saving, our FD which is lying with the bank. So it is our money, and if one person or few people are enjoying by taking the loan, and we are being penalized down the line if the bank doesn't take the action.
Yes, sir.
So according to me, these notices should never be ignored.
Yes.
So EMI should be regularized ASAP.
Yes, because sir, why actually it should not be ignored is that honest person, at least a person who is honest with himself, he knows that the fact that he has not made the EMI payment for so many long time. And so it is not the case that he can't say that I have actually been sent with a notice by the bank without actually giving me any enough opportunity or enough period for repayment. Because of the lengthy time has gone through, the bank has no other option than to actually go and initiate the proceedings.
So, in my opinion, the moment you get a 13-2 notice, you should approach a chartered accountant also and an advocate also, and let the chartered accountant go through the ledger of the bank and the loan agreement. If the interest is wrongly calculated or the outstanding amount is wrongly levied or excessive charges are there, then the borrower can challenge at this stage at section 13.2.
Yes.
Or he can challenge at section 13.4 also.
Yes, 13.2 notice, if there is there and if he has given the reply under section 13.3a, if it is not considered, the borrower will not have direct right to go to DRT. He will get that right if there is 13.4 notice is issued and if he wants to actually go and put his particular remedy, or when a section 14 order has already been passed and before the execution of court commission work, when the court commissioner issues the notice, at that time also he can actually apply for a stay to the particular stay of the particular order.
See, in one of my matter personally, what I would like to say, we had engaged one chartered accountant company, and they find out through the ledger and through whatever ledger we had that there was a wrong calculation of the interest.
Okay.
Right? And when we went to the DRT, we were able to establish that there is a wrong calculation and this is what it is. And still, to show our genuine intention, we are depositing unconditional this amount to the bank or in the DRT, and the stay should be granted. And we were successfully able to get the stay because our client was smart. He also knew some accounting procedures. So we approached one of the chartered accountant, got his certificate that there is a Mills calculation of the interest. So there are remedies. You should not get panic, but immediately approach your advocate and chartered accountant to find if all the calculations are in place, whatever the demand raised by the bank are genuine, or there is some miscalculation, because mistakes can happen. They are not deliberately done by the bank. Bank also is relying on some system, and system, if not checked, they can, make some incorrect calculations or excessive interest, penal charges, wrong classification of account, failure to credit payments. The bank is required to consider such objection and communicate its decision.
Yes.
Many borrowers are unaware of this valuable right. If the borrower files a reply to the notice under section 13, subsection 2 of the SARFAESI Act, what is mandatory requirement on the part of the bank?
The bank has to consider the reply, and within the receipt of 15 days of the reply notice and notice reply rather, they have to actually inform the borrower whether the objection which has been raised is tenable or not, or why it should be considered, why it cannot be considered. And these are the things the bank has to intimate. It's not that the borrower, if he has given the demand notice reply, the bank actually has to the bank should not keep quiet actually. If the bank has kept quiet and if it has not considered, then again, as I said, if it is going to be challenged under section 13.4, then that can be one of the ground which the borrowers actually can get that our point was not considered.
Yes. So now one of the demand notices, once the demand notice is issued, what is the procedure bank proceeds?
Yes, as I said, sir, under section 13.4 of the Act, it specifically deals with the next procedural part. In that case, the bank may take the physical possession or the symbolic possession of the secured asset, or it may appoint someone to take the management of the secured asset, or it can sell the seized property, which mortgage property is there. As I said in my previous answer to the question, most of the times it becomes a symbolic possession because there is no intervention of the court and there is no actually help of the particular police machinery. So 13.4 notice, symbolic possession procedure is most of the times followed by the bank after 13.2 compliance has been made.
Now, what I want to ask you is, notice under section 13, subsection 4 of the SARFAESI Act can be challenged, or I should wait for the section 14 procedure?
No, it can be actually changed, challenge, that is 13.4 also, under section 17. But as I said, there should be some grounds. As you said, we have discussed just now about misrepresentation is there, or if the actually account is classified as NPA in the wrong way. As I said, sir, banks actually banks carries the system, and I would like to add one point is that end of the day system is actually worked by humans.
Yeah.
It's not that it is going to be a system which is running on its own. We have the AI and all this now, but then also in bank system or the loan procedure is there, it is going to be operated by the human beings, and so obviously being a human beings, mistakes are bound to happen. And so it's the thing, and I would actually honestly like to share here is that there is no, as we saw, we say always that the borrowers are in a mental state that the court commissioner and the bank is not going to cooperate us at all. It is not the case, sir. In fact, most cases also, sir, despite the 14th section order has been passed, and when the court commissioner has come to take the physical possession of the property, at that time also there have been instances where the bank authority or the officers have actually honestly told to the borrowers to make the repayment of the amount, or to what remedies are there even if the possession has been taken. So there is a cooperation by the bank, as well as there is a cooperation by the court commissioners also. Even police also tries to actually help the borrowers. Its thing is that there is a wrong impression in the mindset of the borrowers that once now SARFAESI is started, nothing is going to happen. मतलब जो कुछ अभी तक है, जो कुछ हमने वो प्रॉपर्टी के लिए किया है, वो सब खत्म हो जाएगा, ऐसा होता नहीं है. If there is only thing is that there should be honesty and earliest opportunity whenever there is there, you have to go and actually put up before the bank officers.
Whether the further procedure can be stopped once application is made to DRT?
Yes, the DRT will only consider whether the proceedings or the required mandatory procedures are followed by the secured creditor, and it may grant a conditional stay, as I said, for execution of the order if the application is filed after the section 14 application is allowed by the court.
Now suppose if the borrower receives section 13.4 notice that it is served upon him, so what is the next step the secured creditor takes after receiving this notice under section 13 subsection 4 of SARFAESI Act?
Yes, after the section 13 procedure, that is 13 to 13.4, both procedures have been completed, the next step which the secured creditor takes is to make an application under section 14 of the Act before the concerned Chief Judicial Magistrate or Chief Metropolitan Magistrate or the District Magistrate for requesting the particular magistrate for taking the physical possession of the property. Now, sir, most important thing as far as this section 14 is concerned is that unlike the other proceedings or the civil procedure is there or the DRT proceedings are there, in that cases, in other those cases, the borrower has the right to defend himself. There is adjudication of the rights between the borrower and the bank. But under section 14 or this particular SARFAESI, the complete proceeding is actually the entire proceeding is completed by the court by only verification of the documents. So people say that principle of natural justice may not be there. We have a right to defend why it is not given in this particular section 14. The answer for that is it's a special statute, and therefore it allows the particular judicial proceedings to actually go without hearing the borrower. Because in civil matters the borrower is always going to be heard, but in SARFAESI it's a ministerial or administrative part. So unlike the technical, whatever we can say, the rules of law, that is evidence law is there, Bharatiya Sakshya Adhiniyam now. So that have to be technically are not actually required to be followed under the SARFAESI Acts. It's an administrative or the ministerial particular act. Now what section 14 says is that there are some principles regarding 14 section which has been elaborated by the various judgments of the Honorable Supreme Court and High Court. First of all, that it is not an adjudication of a dispute. Second, the application should mention by the creditor that when the particular loan application was actually made by the borrower, when the loan was sanctioned, whether the borrower has created any security, when the borrower has made a default, when the account has been made as a non-performing asset, when there was the service of demand notice, and whether it was served or not, and if it was served, whether there was any objection was there, and after that, if the compliance of section 13(4) has been dead. So these are a few things which actually this court has to consider. The most important thing is that the act says that since it's a special statute and expedient remedy for the banks, this act says that once the application is filed before the concerned court, the court has to actually make the order after receiving the application within 30 days, which can be actually aggregately extended to 60 days. So there is, as I said, there is no service of notice, there is no adjudication of right. So because this is the point, sir, because borrower says that court की order हुई हमें पता ही नहीं था. Even sir, sometimes borrower says that the orders are actually what we can say made fake on this. It's not the case, sir, because when the court commissioner goes to take the possession of the property, he is actually issued a read by the court to take the possession of the property, which is with the seal of the court. So under section 14, sir, if we simplify, it's an administrative and ministerial part, and there is no adjudication of disputes, and the court is duty bound actually. So, sir, shall and may, there are two differences there. When there is a shall provision, it is a mandatory on the part. It is actually Supreme Court has even said that it is a directory as not mandatory. So what is mandatory is that you must, in directory means if there is non-compliance of that 60 days, it doesn't mean that the application or the proceedings becomes unlawful. It becomes a legal action, but there are certain restrictions or certain guidelines which specifically this section 14 has actually given to the honorable courts.
Yeah, even the Supreme Court and various High Court have from time to time reaffirmed that the nature of proceeding under section 14 is administrative and ministerial. What exactly the courts have said, because lot of the times borrowers say we have right to participate in section 14 proceedings since notice is not issued and we are unaware of it.
Yes, the Supreme Court has from time to time, there are few judgments. The first judgment I would like to mention is NKGSB versus Subir Chakravarti. Now this citation of Supreme Court is most important for two aspects. It considered the first aspect that the time is the essence under section 14 of the SARFAESI, and so there should not be undue delay by the magistrates, chief judicial magistrate or the metropolitan magistrates before passing the order. So order should be passed expediently. And in this case, second thing which was considered was appointment of a court commissioner, whether a court commissioner can be appointed for taking the possession, whereby the Supreme Court said that the court commissioner is an officer appointed by the court, and so he has every right. Another sir case is there, Balakrishna Tarade versus Phoenix ARC. Another case is there. In that case also, sir, actually Supreme Court has said that time is the essence of the particular SARFAESI Act, and the borrower has no right to participate in the proceedings under section 40.
Once the order is passed by the court under section 14, is it mandatory to intimate to the borrower?
Yes, as far as the order under section 14 is concerned, the court actually, while passing the order, makes clear that the court commissioner who is appointed by the court, he or she shall actually issue the notice to the borrower. 15 days mandatory notice has to be issued to the borrower before taking the possession of the property.
See, one thing I would like to discuss, an issue, this is on a humanity ground, and that continues to generate complaints from the borrowers even today. During the COVID-19 pandemic, RBI permitted banks to offer a moratorium or loan repayments. Many borrowers believe that the moratorium meant a complete waiver of the EMIs or interest. Several borrowers have informed us that they signed the documents without understanding and the consequences later. They discovered that the additional interest or the interest what was agreed, initially it was 14% or 15%, now it has been increased to 18%. Compound interest, penal charges, revised loan terms had been imposed. Can you explain what actually happened?
Yes, this is one of the important aspect which I would like to here actually clarify. During the COVID period, the COVID moratorium was announced by the RBI, and it was generally the reason why this actually decision was taken was that it was actually for deferment of payment and not for the waiver of loan amount. The reason behind is that because due to COVID there were restrictions, many businesses stopped, people were actually having work from home, even there were limitations for traveling from one place to another. And even for the persons, that is in cases of home loans also, the surviving person, the family member, head of the family member, could not actually go and actually have the work, and so therefore he could not actually repayment the make the repayment of the EMI. So generally it was the assumption of the borrowers that if this particular, as per this particular guidelines of the RBI, our loan is actually what we can say waived by the bank. It was not the case. It was only a temporary arrangement. It was actually deferred for a certain period. It didn't say that your actually particular EMIs are going to be waived at all. There is the interest which is there, we are not going to calculate the increase, or the banks cannot calculate the interest. It was not such case. But what happened was that it was interpreted in a wrongly manner, and therefore people thought, okay, we have got this guidelines of the RBI, so why not actually make as a shield of a defense?
No, actually, I'll tell you, in many of the cases which I have received, they were made to sign, right? The loan interest also was increased, from 3 to 4% or maybe more. And what the idea the borrower had is that they will not have to pay the EMI and no interest, but on the contrary, the loan amount was increased. Compound interest was added. So this clear picture was not given to the borrower. He was just made, he was told to come to the bank, a cup of coffee or tea was given, and he said, yes, हम आपका सब ध्यान रखेंगे, आप ये sign कर दो. And subsequently the EMI also increased, the interest also increased. So my personal opinion is, when you are signing any documents while taking the loan or restructuring the loan, at least take some legal advice from your chartered accountant and from your advocate, so that you don't fall into the trap. And because of this pandemic, people have, lot of issues. Legal issues have been created, and they are now becoming what you call defaulters.
Yes, because in that time what happened was many proposals were accepted by the banks by online apps or emails or there, and borrowers actually thought just for a temporary relief. They actually tried to they didn't actually understand the terms and conditions of restructuring agreement. Now, sir, during moratorium, as I said, there were two parts. One was about moratorium, that is for waiver of, not a waiver of the loan amount, but deferment of a loan amount. And second was restructuring agreement, by which actually what happens is that the EMI structure actually changed, the duration changed, and therefore as a result the principal even it more actually increased more after the pandemic came to an end.
Yeah.
And so for that is the, as you said, because the restructuring agreement was not read, there was misconception by the borrowers that we are actually not understood the particular things, or the agreement was there.
And my personal opinion is that this was done deliberately. Now, what I want to ask you a sincere question, not as a court commissioner, can such action be challenged before DRT?
Yes, it can be challenged, as I said, under section 13(4) also, when we had the discussion about the challenging the court the proceeding before DRT. Misrepresentation, one of the ground is there. If there is unfair practice by the bank, or if there is a violation of RBI guidelines, or as I said, there is incorrect calculation of interest. In such circumstances, if there is a genuine thing, then those things can be definitely challenged before the DRT, and the DRT will consider those facts also. So not in actually every case, but there may be chances where out of, we can say, 50% chances that the genuine whatever efforts have been put by the borrower before the court.
Now this discussion has given one more thing in my mind is, can we approach to the consumer court for misrepresentation, unfair banking trade practices, or violation of RBI guidelines, incorrect calculation of interest, or unauthorized enhancement of liability.
Sir, as far as the consumer protection is concerned, it will be applicable for deficiencies if services it can actually it be taken into consideration. But as I said, sir, most of the times since it's banking institutions and resolutions are under the purview of this,
DRT.
so technically no, it won't be applied to consumers.
It won't be, but let me have this discussion with my legal luminaries of consumer code also from Mumbai to Delhi, that if such things have happened, so there is a misrepresentation, then there is an unfair trade practice or unfair banking practices, and incorrect calculation of interest or unauthorized enhancement of their liability. So I will once upon ponder on this with the legal luminaries of the consumer courts from State Commission to NCDRC to find a way out that how we can help the borrowers who have been, fallen into this trap unknowingly. They thought that moratorium period जो आया है उसमें हमको इंटरेस्ट नहीं देना है या हमारे इंटरेस्ट जो EMI है वो वेव ऑफ हो गए. But in fact, their liabilities have been increased. The interest have been increased.
Yes, sir.
And the loan tenure has also been increased. So that has all happened unknowingly, where there was no intention of the borrower to do any default or do any cheating with the bank. In fact, what I feel is they have been cheated. Now, one more thing is, can the borrower take the possession of the property if execution is completed as per the order under Section 14 of the Act?
No, sir. The borrower loses the right to take the possession of the property once the order under Section 14 is executed. And as a result, even the secured asset is coming in the possession of the particular bank, the bank it comes in the possession, so there cannot be illegal possession by the borrower. If he tries to break the particular house, the possession which has been taken in the procedure which has been followed in the presence of the court commissioner and with the order of the court, in such cases the borrower cannot go and actually take the possession of the property. It might result, there have been cases where there has been house trespassing, and then another FIRs have been actually filed, and so another criminal proceeding is actually there. So instead of actually having solution to the problem, there is more and more problems have been created by the borrowers. And sir, one thing I would like to here mention is that there are some misrepresentations made by the to the borrowers by the people itself. It's not the case, sir, which I actually personally think, which in my experience is that there have been some actually things which have been deliberately told to the borrowers that you don't worry, nothing can happen and देखा जाएगा कुछ भी, आप कुछ मत करो. So these are sometimes I have seen that there is not actually proper guidance is not given to the citizens by their actually own friends or
the advisors who are incompetent to advise them on this particular topic.
What happens is that one wrong advice can actually
ruin them,
and one wrong advice can lead to losing of the property, and it will affect for the generations also, because it is going to be end of the day your property is going to be yours if you are actually honest and actually you want to actually protect the rights for the future of the family members also. Small children are there, wives are there, anybody, because as I said, food, shelter is the one of basic ingredients, basic requirements, and so every person has his love and affection to the particular property. Sentiments are there and emotional part is there, and lot of hard work is also there. So to lose the property because of the wrong advice of the people, it should not happen. That is what I actually want to make here aware to the citizens.
Now, what is the process the bank should follow after the possession is taken under Section 14?
After the after the possession has been taken under Section 14, the bank actually puts the notice to the conspicuous part of the house. Also, it publishes it English newspaper as well as local newspaper within 7 days that so and so property has been taken. After that, the valuation of the property is made by the government approved valuer. After the valuer has given the report, then actually the bank proceeds for the auction processes. And that for auction processes, again, sir, one important point is that when there is an auction of the property, at that time also, sir, the intimation of the auction is given to the borrowers that so and so auction is going to take place. So that time also, if there is some what you can say any ground, and if there is any possibility, they can actually go and actually make the repayment.
So Narendra, how challenging has been the experience as a court commissioner in SARFAESI cases? Can you share one of the challenges which you will remember even if I wake up you in the middle of the night?
Yes, sir. There have been, as I said at the first instance, there have been quite challenging circumstances. As I said, the example which I gave at the start of our podcast, the person was actually lost his wife due to COVID and he couldn't pay the EMI. At one point after the completion of work, the court commission came to work completed. I gave the report, submitted to the report. But after which I just actually thought in a different manner also in that cases. But one thing is if there is a proper cooperation by the citizens as well as the borrower, and then also, sir, in that cases also the court commissioner actually will definitely go and actually help the particular to resolve the particular problem, because see, court commissioner is appointed by the court and is an advocate. So being an advocate, he knows the law, he knows what are the rules and regulations. One thing is also more clear, I would like to make clear is that the court commissioner does not act as a mediator in the cases. He can actually help, but he is not a person who is going to actually make any settlement between the borrower and the banks. It is the ultimate decision of the bank authorities what decision has to be taken. But as I said, it has been quite challenging to go to various remote places in our place in Ratnagiri district also, because of the court commissioner work, sir, on ground work whichever has been done. They actually act how it is to be enforced in reality. I actually understood the act more easily because of the court commissioner work instead of the statutory work. And also one thing is that as a court commissioner, it is a duty of the court commissioner to actually give the possession of the property. So you have to be honest with yourselves, as well as you have to be, what we can say, you have to respect the orders of the court, which is binding, but the bank is also binding, the court commissioner is also binding, and the borrowers are also binding. So there is a sense of responsibility. Every time whenever there is a court commission, I always think in that way it's my responsibility to actually give the possession of the property. And if there are circumstances, then you have to take little bit harsh steps. Because then even there is some mentality has become now that borrower will go and actually give some bad words and he is going to actually not cooperate it. So that is the mentality, sir. After 4 years, I can say just now. So when we actually expect the maximum thing, then it becomes very easier. When we anticipate max things which could happen, it becomes easier in other court commissions also, because it's not that every time the borrower is going to take such what we can say extreme actions. So it has been very, very quite challenging, but it has been very interesting also.
So now, what practical advice would you give to the citizens today?
Sir, my advice to citizens is that whenever you are going to take the loan, first read the loan agreement properly, terms and conditions. Understand the rates of the loan interest rate which they are going to be charged. Tenure of the rate, whatever the loan is there. What will be the EMI every month? What will be the consequences of non-payment of EMI? These are the things which are there. They have to consider. If there is a restructuring of agreement, which as we discussed in the COVID, go and understand what are the particular things which the restructuring agreement is going to affect the particular borrower. If there is interest rate is going to interest, how much it is going to be interest, it is going to be increased, as well as what will be the tenure there. So though understanding those things is most important thing, and for that purpose you can seek the legal advice of whenever it is possible.
So with this, I thank Narendra Athavale that to make us aware of the SARFAESI Act, he has come all the way from Ratnagiri to be the part of the podcast, even in the season. But I am thankful to the rain god also that the rain was not there. He came to the office in time, and now again he is going to take a train at 4 o'clock to go back to Ratnagiri. So myself and Narendra Athavale, we suggest that whenever you are taking a loan, do a proper study. Keep the copy of the agreement before signing on the dotted line. Take some advice of your chartered accountant, take some advice of your advocate, so that in future you don't feel that you are fallen into the trap. And this moratorium period thing is there. I am working. I will still discuss with him. I'll still discuss with the senior advocates that if they were being made to sign on the dotted line without understanding the implication of the moratorium period, and their interests have been increased, their liability have been increased, and their tenure have also been increased. So what is the remedy left to them? So with this all, I thank you all of you for watching this podcast, and if you like it, kindly share it. And if you want any further advice from Narendra Athavale, advocate who is specialized in this SARFAESI Act, I will request him to share his contact number so that you can easily approach him. And he has made one PPT also. So in the description, I will give the link of that PPT. You can open and you can, again go through the sections what he was referring.
Yeah, I would actually like to thank Honorable Sir for giving this opportunity, for putting my opinion and whatever study of regarding to this act is there on this very big, what we can say, it's a platform like YouTube and the channel. So that, and for it's a very big opportunity in the sense because we often don't get that much opportunities being practicing at a district place to come to Mumbai or to be associated with any particular firm and to actually express ourselves and to actually share the knowledge, because sharing of knowledge, it becomes very easy, and therefore I am very thankful for this opportunity.
Thank you all very much.
Thank you very much.